A current hot topic is the imposition of a legal minimum when conducting excavation works. Article 439 of the Civil Code states that when one is excavating within his own property, one cannot excavate within 76 centimeters from any adjoining property. This limit is imposed by law, and therefore the only way one cannot adhere to it is if the neighbouring owners consent to it, and this by means of a public writing. Once the creation of this easement is imposed by law, and is therefore a servitude. The remedy applicable when one finds out that his neighbour is going to excavate within the 76 centimeters limit is to file a warrant of prohibitory injunction. This is practically a warrant requesting the court to order a stop to all the works, especially the excavation works, within the neighbouring property. The court will assess the situation and will give a decree on whether the works should be provisionally stopped or not. If the decree accedes to the plaintiff's request and therefore the works are stopped, the plaintiff will be bound to file a court case within 20 days from when the decree is given. It is important to take action before the works are finalized, because obviously one cannot stop someone from doing something which has already been done. In any case, if the excavation works have already taken place, however, the building has not started to be erected, one still has a remedy at law, since the court can impose the building of a structure which will work as though the rock is still present before the excavations would have taken place. Who is responsible if this legal imposition is not adhered to? Obviously, the obvious answers are the contractor and the architect. It is of tantamount importance to keep the legal distance, because it is the distance which effectively safeguards the neighbouring tenements. Should any damages ensue in the neighbouring tenement and the legal imposition is not adhered to, then it will be more than obvious that such damages would be caused by the fact that the 76 centimeters would not have been respected. Moreover, the 76 centimeters is the minimum imposed by law. Jurisprudence states that if the circumstances of the adjoining buildings are such that require a bigger distance rather than just 76 centimeters, they would require 1 meter, 2 meters, or whatever it is. Most of the time this depends on the subterrane underneath the buildings and on the pediments of the building. Then the contractor and the architects are obliged to keep a higher distance. The responsibility on keeping the distance required by law effectively lies most of the time with the architect and the contractor, since they are the professionals which should know better and which should know that this distance is required. The contractor cannot hide behind the fact that the architect told him to excavate within the legal distance, and at the same time the architect cannot hide behind the contractor stating that he did not know that works were being carried out, especially if the pediments in the adjoining property are left uncovered for a considerable long time. Therefore, the responsibility lies within both the contractor and the architect. Should the 76 centimeters distance be adhered to, as is imposed by law, however, damages are still caused to the adjoining properties, this does not exonerate the architect, the owner, or the building contractor from responsibility, since they are still liable for any damages which may be caused to the neighbours. One must also realize that responsibility is not always only civil, but not keeping within the legal limits could give rise to criminal responsibility as well, especially should the damages caused to the neighbouring properties lead to any grievous injuries of the people living inside those properties, or at a worst case scenario leads to their death. In that case, such lack of adherence to the law can lead to criminal prosecution for involuntary homicide or involuntary bodily harm.